tabs keep going.
Okay.
Okay.
We're going to talk about separation and divorce in North Carolina with a heavy focus on preparing yourself financially for separation and divorce. Again, I'm Yasmin Morton. My law firm is in Raleigh, North Carolina, off of Lake Boone Trail. As stated, I'm a Raleigh native, graduated from Western Carolina University, and continued my education at Wake Forest University School of Law. And I started the Morton Law offices in 2010. Before I introduce you to my staff, I want to say that I have a reason for being here today. As an attorney for nearly 20 years, with 16 of those years being in family law, and as a divorcee myself, what I have learned over time is that women often tend to be the least prepared financially for divorce. And it breaks my heart to see time and time again that through negotiations and in court, we're being taken advantage of because we're considered to be too emotional, or because we're actually being controlled by our spouses, or simply because we traditionally do not handle finances in marriages. But I strongly believe that knowledge is power. And so I'm here today to empower you and share with you what steps you need to take if you are faced with a separation and divorce from your husband or wife. So that's my take, and I know that my staff's goal is to empower you tonight as well. So without further ado, I'll let my paralegal Jen introduce herself, and then the legal assistant Kushi will introduce herself before we begin with the program.
Hi, good afternoon. My name is Jennifer Flores, and I am a bilingual family law paralegal. I have over 6 years of experience in family law. I have worked with family law cases both in North Carolina and Florida, and I am fluent in English and Spanish.
Hello, everyone. My name's Kushi. I've been working at Morton Law offices for about 6 to 7 months now. I'm super interested in going to law school, and I've always been very interested in family law. I've also been a Kiran volunteer for almost over a year now, and so this event is very special to me because I'm able to bring like my two passions together and hopefully help someone today.
So our goals tonight are to help you understand the definitions of separation and divorce in North Carolina, to help you understand the steps to dissolving a marriage, and to prepare you financially for the end of your marriage. So let's start with separation because there's a lot of misinformation about what constitutes a separation in North Carolina. There is no such thing as a legal separation. Oftentimes, clients or potential clients will come to me and say, Attorney Morton, I need a legal separation. And the first thing I say is, well, what does that mean to you? Because that's not a phrase that we use in North Carolina. Many people think that you have to have something in writing to prove that you are separated, and that is a mistruth. Separation in North Carolina means that you and your spouse must be living in separate residences. One spouse must have communicated to the other that they no longer want to be married, but there is no writing required to prove a separation in North Carolina. Now, if you look at that first bullet point where it says living in separate residences, you'll see that there are two asterisks there because there's always an exception to every rule, but this is not an exception. I have a case where the husband filed for divorce because he lived in Pennsylvania and wife lived in North Carolina. On its face, it appears that the parties were separate, but in reality, they had not separated. It was a family decision for the husband to work in Pennsylvania and the wife to remain in North Carolina. It just made financial sense for them to do that. But he had not communicated to his wife that he wanted to be separated or that he wanted to be divorced, and she had not done that either. So although they lived in separate residences, because neither one of them had communicated that they didn't want to be married, they were not in fact separate or separated. And that was further proven by the point that they would attend family reunions together, children's events together, they would go on vacations together. So living separate and apart alone is not enough. There must be an intent to no longer be married. So if your ex lives in a, or if your spouse lives in a different state or a different country, just because that is the case does not mean that you are technically separated. So let's talk about what separation is not. Separation does not mean that you are on the top floor and your soon-to-be ex is on the bottom floor. Separation does not mean that you're sleeping in separate rooms. Separation does not mean that you are spending some nights at home and some nights away. You have to physically be in two different residences for it to count as separation in North Carolina. Can you see the screen now?
Yes.
Yes.
Okay. So that I can give you a visual, I will go back to what separation is. Living in separate residences, one spouse has communicated that they no longer want to be married, and no writing is required. Separation is not sleeping in separate rooms within the same home, living on separate floors within the same home, or spending some nights at home and some nights away from home. In order to qualify for a divorce in North Carolina, 5 things must happen. First, you must have a valid marriage. Second, at least one spouse again must have relayed their intent to separate from the other. You must have lived separate and apart for at least 1 year and 1 day before filing for divorce. And you must not resume your marital relationship at any point during that separation period. If y'all try to reconcile, that will start the clock over for that 1 year separation period. And 5, at the time a complaint for divorce is filed, one party must have resided in North Carolina for at least 6 months. If you've only been here 5 months and your spouse lives in a different state, you do not qualify to file for divorce in North Carolina. You must have resided here for at least 6 months prior to you filing. How do you file for divorce? I think this is important because although we are talking mainly about finances, not everybody has a custody case. Not everybody needs child support or alimony. Sometimes you simply need to be unmarried. There are 4 required documents to start the process. If you want to screenshot this page, be my guest because this is what you're going to need in order to get the ball rolling. First, you will need to file a complaint for divorce. North Carolina has some DIY forms. Many counties do as well. Wake County does. Simply, you fill in the blank, as you can see on the screen. Plaintiff is a citizen and resident of Wake County, North Carolina. You can do this on your own if you feel comfortable. You really cannot mess up the fill in the blank forms, but if you don't feel comfortable, you can contact an attorney. In Wake County, on the first floor of the courthouse, we have a self-help clinic where attorneys volunteer and they will help you with this process for free if you want to go that route. The most important thing is A, that you tell the truth, and B, that you have the document notarized by a notary. You need to sign it in front of a notary, and the notary needs to put his or her stamp on it. In addition to the complaint for divorce, you will also need to file a domestic civil action cover sheet. And this is what that looks like. Again, you just fill in your information and you check the boxes that apply to you. So this would be a complaint for divorce. After you have the complaint and the civil action cover sheet, you will also need a civil summons, which is here. Fill in the blanks, fill in your information, and that's what you need for the civil summons. And finally, you will need a Civil Relief Act affidavit, an SCRA is what we call it. And what this is you are certifying to the court whether your spouse is in the military, and if so, whether he or she is active duty or not. Active, active duty military personnel receive some protection so that we can't just divorce them without them having any notice. Now let's move into separation. Whether you're thinking about separation or whether a separation is thrust upon you and you don't really want it, here we are. You have to face the facts. What do we need to think about? If you have children, obviously, we need to think about our children. What will time with each parent look like? Who will make child-related decisions? Property. People think of property as being houses, but property includes houses, cars, bank accounts, retirement, furniture, credit card debt, you name it. It probably falls under the category of property. But a huge category is finances, and that includes child support, post-separation support, and alimony. We're going to start off by talking about child support. In child support, you have 4 options in North Carolina. You can go through the child support agency. You can hire a private attorney to help you secure child support. You can represent yourself, or you can enter into a separation agreement with your soon-to-be ex. Whichever route you choose is the route you choose. There's no right or wrong answer. I will say that oftentimes, if both spouses are W-2 employees, meaning they work for someone and they get a W-2 in January of each year, I will urge them to go through the child support agency because it is a nominal fee, somewhere around $20 to file and to secure child support, whereas a private attorney can be tens of thousands of dollars. But if your spouse is underemployed, unemployed, self-employed, I'd probably tell you to hire an attorney because an attorney is going to do the digging to get you a fair amount for child support. Separation agreement, if y'all are on good terms and y'all can sit down and come up with a number that you believe is adequate to support your children, you can write that up, get it notarized, and you're done. And finally, if any of those are an option for you, you can represent yourself. No matter which route you take, there are going to be certain documents that you will need. So where do you begin? First, you'll need your federal and state income tax returns for the last 2 years, including all W-2s. This is Wake County specific, but Durham County is also very similar to what we require in Wake County. And I would hedge to guess that Mecklenburg and all other counties require just about the same documents. 2, you will need pay stubs for at least the last 3 months. 3 says all documents reflecting income from any and all sources for the last 2 years. That will include bonuses, gifts, alimony, any money that you pulled from your retirement. There is a very broad definition for what we consider to be income in North Carolina. If you have any stock options, you'll need to pull those records. Bank statements for the last 6 months. Credit card statements for the last 6 months. Even if you're only an authorized user, you will need those documents. You need to inform the court and the opposing party of any place that you hold your financial accounts, including the account number, name on the account, institution, etc. If you own a business, we'll need your business tax returns for the last 2 years, your business bank statements for the last 6 months. And going back to number 3, here is a comprehensive list of what we consider all income sources to be. I highlighted bonuses because oftentimes people get bonuses and they want to say, well, this should not be included. This bonus is not guaranteed. I don't know if I will get it again next year, but you got it this year. And we're calculating child support based on this year. So that bonus will likely be included. Gifts and prizes. Many times, me, for example, when you separate, you don't have the financial needs to care for yourself and your child, and you're relying on family members or friends to help assist you. The money that they give you can be considered income, and that can be used in the child support calculator to determine how much your income is, especially if it's on a recurring basis. So if your parents are giving you $1,000 per month to help you sustain, a smart attorney on the other side would say, well, they're getting that consistently, $1,000, judge, that is income. So be mindful of that. You'll also need to start collecting documents relating to health insurance. If you're providing health insurance for your children, we'll need that documentation. If you have after-school care, daycare, before-school care, summer camp, we'll need that documentation. Documents reflecting any extraordinary expenses. That includes if your child has special medical conditions, potentially private schooling. Private schooling is not guaranteed to be considered. Expenses for transporting the children between the parties' homes, especially if y'all live miles away in different states, that could be considered. And documents regarding any obligation for child support for other children. So if you have a child from a previous relationship and you owe child support, then that will be considered. Now, this is a 14 bullet point list of things that we need. And I know that most people are not going to have all 14 of those items. And many times they don't know where to find them. What I tell my clients is even if you don't know where to find them, especially if you're in the exploration phase of separation or you're thinking about separation, start paying attention. If your spouse has mail coming to the house from BB&T, you may not know the account number for that, but at least somewhere in your notes section on your phone or in your memory, write down BB&T. Because just like you have to turn over these documents, your spouse has to turn over these same documents. And the majority of the time, if you're not financially aware of what's going on in your home, the other spouse will hide the documents. As a private attorney, if you at least know that John Doe banks at BB&T, we can issue a subpoena to BB&T for all of John Doe's bank records, and we will get every account that he has. If you know that he has a retirement, but you're not sure how much money he has in there, give me his employer. Give me the name of the retirement provider. Any information that you can give will be helpful. So start paying attention, start writing it down in a place that your spouse will not know where to find it because you are preparing yourself. You don't want to be behind the ball. You don't want to have to rely on what he's telling you, knowing that he's probably not telling you the full truth regarding his financial circumstances.
And before you move on, we had one question in the chat. What if the assistance from parents is to help subsidize the lack of income from the other spouse?
Oftentimes it is to help subsidize. But if I'm representing the other party, I am still going to argue that it is income if it is coming in on a consistent basis. because that's what the North Carolina child support guidelines say. You can make an argument that it's not, and you can be successful on that argument, but you just need to know that the other side is going to make that argument. The counter argument would be, I would not need my parents to help subsidize my income if he was paying child support like he was supposed to be. I think that's a very, very compelling argument. A court will consider it, and many times the court will say, you're right, because the non-custodial parent has an obligation to provide support for their children. If they don't provide support for their children and you have to take it to court, the majority of the time the court is going to make them pay child support like they were supposed to and pay your attorney's fees for having to go to court. Because the theory is that we should never have to go to court to make you pay for your children. We're going to give you some live examples because child support is based on a lot of factors. It's based on the number of overnights each party has with the children. So for this purpose, we're going to say mom has custody of the children. And dad, they are spending less than 123 overnights at dad's house. So they are with mom the majority of the time. That's going to be our first scenario. Our second scenario is going to be that dad has exactly 123 overnights with the children. And our third scenario is going to be that it's 50-50 custody, you share it equally. I'm going to show you the financial implications of how many overnights your children spend with your ex. And for the first example, Kushi is going to lead us.
So, as Attorney Morton said, that first worksheet is talking about less than 123 overnight. So, in this scenario, we're just going to say that there is four children involved, and they are spending a majority of the time with mom. So, we're going to have mom as the plaintiff and then defendant as the dad. So, let's say the plaintiff, the mother, is making around $50,000 a year. For the monthly gross income, you would divide that by 12 and you should get around 4,166. Let's say the dad makes double. He makes 100,000. Divide that by 12 to get that monthly gross income and you'll get 8,333. So the next two parts that you fill out, pre-existing child support payment. For the sake of this example, we're going to say that neither parties have any pre-existing child support payments and neither parties have other children. So we're just going to be focused on these four children. But the numbers would change again if you would put in numbers for the child support payments pre-existing and the number of other children. Work-related childcare costs. So this is anything from after school, before school, like she mentioned before. For this example, we're going to have the plaintiff, the mother, paying about 400 or 200 in total for all the children, all four children, and the defendant paying zero. So the father is not paying anything related to childcare, but the defendant, the father, is still paying insurance premiums, and so that would be 400. For the insurance, you would calculate that by taking, sometimes your insurance plans will tell you how much is dedicated or allocated to the children, but if not, for the sake of this, let's say it's about $600. For the total insurance, we're just going to divide that by six for the total number of people in the household. And then you'd get 100, multiply it by four for the four children. So a lot of insurance plans should already tell you how much you're paying just for the children, but that's how you can find it if they don't tell you exactly how much is being allotted. And we're going to say there's no extraordinary expense. So this is actually a website online. You can go through this entire worksheet and fill out your own numbers, and they'll give you the number that the whoever is owing in child support. So for this example, what we just filled out, the father is going to be owing 1,948 in child support each month, and that would be for all four children, not each.
And that's because he has less than 123 overnights with the children each month. We're going to use these same numbers and show you what child support would look like if he has 123 overnights. And Jen is going to walk us through that.
Okay, so we'll start as Attorney Morton mentioned, this is when they at least have 123 overnights. You'll be using what we call worksheet B. And we're just going to use the same values that Ms. Patel used on her example. So we are going to have 4 children, and we're going to have the mother making 4,166 a month, which is the 50,000 yearly. And we're going to have the father at 8,333 a month as well. For the sake of the scenario, we're not going to add any pre-existing child support or any other children. The difference between worksheet A and B is that we're going to be including the number of overnights that each parent has with each child. So for the mother, for this situation, we're going to put that she has 242 overnights. Because there are 4 children involved in this scenario, you would times it by 4, which will equal 968. We're going to do the same for the father. We're going to do 123 overnights, times it by 4, which is 492. For the work-related childcare, mother will be paying 200, father will be paying 0. When it comes to the insurance, father will be paying the 400 and the mother will be paying 0 on that. We're not going to add any extraordinary expenses on that. And if you were to calculate that amount, the father defendant will be paying 1,445 in child support each month.
Next, we're going to show you what it could potentially look like if you have 50-50 custody. And I will say that our courts are trending towards 50-50 custody. Trending, but it's not a guarantee. Every case is different. Keeping the same figures for children, mom making 4166 per month, dad 8333, no pre-existing child support for any children. The overnights are identical. 730 overnights for all 4 children with mom, 730 overnights with dad, mom still paying $200, dad paying nothing, but dad paying $400 in health insurance for the children. That 1948 that Kushi gave you, that 1445 that Jen gave you, if you're at 50-50, now drops to 730. So this is a financial consideration. First and foremost, what's best for our children comes first. I will tell you the reality of child support. Dads, we're going to be stereotypical for a minute, are well aware of child support. A lot of them do not want to pay child support. Why should I have to pay child support if I have my children? Why can't mom afford child support? If she wants the kids, then she should pay for them. So they are aiming for 50-50 because they know that 50-50 gets them a low child support amount. I'm going to say though, if those numbers were reversed, this is important for moms to remember. Worksheet A, you still get child support if you're making the 8333 and dad's making the 4166. You still get child support. If dad only has 123 overnights and you're making 8333 and dad's making 4,000, you still get child support. But at 50-50, if you are making 8,300 and dad is making 4,100, you are likely paying child support for your children. And one of the questions in the chat was, how long does child support last? Child support lasts until the child is 18 and graduates high school. So if your child turns 18 in January, but they don't graduate until June, child support continues through June. If your child graduates at 17, goes off to college and turns 18 in September, child support continues while they're in college until September. If your child has been held back and they are 19 and in high school, you're still getting child support because it's not 18 or graduates, it's 18 and graduates. And both prongs are not satisfied until that child graduates from high school, as long as they are making reasonable progress towards their diploma, meaning they have to be going to school trying to graduate. Along with child support, many women are often eligible for spousal support. And while we're not going to go into as much detail with spousal support as we did with child support, we are going to show you what we require in Wake County after we talk about the child support options. Again, you can hire a private attorney, represent yourself, or enter into a separation agreement. There is no alimony agency. These are your only three options for spousal support in North Carolina. You hire an attorney, you enter into a separation agreement, or you represent yourself. Regardless of the route that you're taking, that 14 bullet point slide that we showed you of the documents that you're collecting still apply to spousal support. In addition to that, you will be required to fill out a financial affidavit. Again, this is Wake County. Most counties have financial affidavits. They may look a little different, but the gist is the same. What you will need to know is what your date of separation values were. So if you separated a year ago, when you fill out this first column, you need to put your year ago numbers. What was your monthly gross income a year ago? Was your rent and mortgage a year ago? So that's where that document collection ahead of time helps you through the process. It is very stressful and overwhelming to get this document and have to collect documents and have a deadline to turn this financial affidavit in. So that pre-planning is very helpful. In addition to your date of separation numbers, you will also have to give your current values. What are you currently paying now? Many times, going to that, my parents are helping subsidize. Many times people move in with their parents, and so there is not necessarily any rent. I would not tell you to put zero here. What I would tell you to do is look at a place that is suitable for yourself and your children if you have children, and get some estimates of what your rent would be if you were able to afford rent, and put that in that column. What would your cable be if you were able to have cable? This is a 6-page document. It includes everything you can think of: phone bills, dental, school lunches, vacations, credit card debt, student loans. You put all your financial information on this document. And what it does is it will show you what you need to sustain yourself on a monthly basis. Again, your spouse will also do the same thing. If your spouse is the breadwinner, 100 out of 100 times, they will overestimate what it is that they need. Because for the temporary spousal support, it is based on needs and the availability of extra funds for your spouse to pay you. So your spouse is going to say that they are flat broke, they have no money to survive, and they're making $300,000 per year, and they can just not afford to pay you anything. What a court will do, what an attorney will do, is we will pick apart the numbers on this worksheet and say, oh, you have no money to pay, but you're spending $2,000 per month on vacation. That's discretionary spending. You have no money to pay, but you are in a fraternity and you're paying $150 per month. That's discretionary spending. We are picking apart their finances to find money that can go to you to help you simply survive. This is a financial affidavit. This, like your complaint for divorce, will need to be signed and notarized in front of a notary.
We had a question about the financial affidavit.
Yes.
Someone asked how early can we fill out this document?
I think that well, you can't fill it out before you separate. It's the obvious answer. I think that the sooner after you separate, you at least fill out that first column of data separation values, the fresher it's going to be and the more realistic your numbers are going to be. If we're going to court for court purposes, I would tell you to hold off on your current because we really want to know what your current values are. If you fill out a financial affidavit now with your current values and we don't get to court until December, your numbers are probably going to be very different in December than what they are now. So I would go ahead and fill out the date of separation values, but the current, I would push it as close to court as possible if you're going to court. If you're just using it to give you guidance on the separation agreement, go ahead and fill out the current values. But we want an accurate reflection at the time we're presenting this to a court to show the court what your needs were then and what they are now. I'm going to stop sharing my screen so that I can look at everybody. Are there any additional questions about anything that we've discussed so far?
Yeah, so we had a few questions. Do I need an attorney for filing a separation agreement?
So it is not required that you file a separation agreement in North Carolina. I have never filed a separation agreement in North Carolina. A separation agreement is a private contract between you and your spouse, and it simply needs to be notarized and signed by the two of you. You each will keep a copy of the separation agreement.
We had another question as well. Can one parent travel to their home country if there is no court order in place? There is abuse, so the survivor wants to go back where she has support.
The short answer is yes. My answer as an attorney would be to tell you not to do that because I can guarantee you what your ex is going to do is they are going to go to court. They are going to file for emergency custody, saying that you are fleeing the state of North Carolina with an intent to evade jurisdiction. A court would likely enter an emergency custody order requiring you to bring the child back to the state of North Carolina, and they may very well grant your ex emergency custody of your child without you having any visitation. So no, I would not have, yes, you can do it, but no, I would not advise you to do it.
We also have a follow-up question. Um, can you clarify this question? It says, what if they travel out of the country, not to another state? Whoever asked this question.
Yeah, so what if the client wants to maybe, let's say, for example, travel to India with the child, not to another state in the United States?
And they
Travel,
would be coming back.
Um, yeah, because sometimes we have some of our clients, they have the support back at home in India. So they intend to go and just remain there with the child than just staying here. And also we have some clients just to want just they want to be away for a while so that they will go and then come back. In both scenarios, what could be the repercussions?
if you're going with the intent to stay, I would say no, because I would say again, your ex is probably going to file for emergency custody if they're here in North Carolina, and the court's going to order you to bring the child back. If you're going to visit, I think your ex probably would still file a motion for emergency if it was a contentious separation. And emergency custody, the court is only hearing one side of the story. So your ex is going to draft a document saying that you are fleeing, you are not coming back. They are so concerned about their child. They don't know where you are, and ask the court to order you to bring your child back. So I would likely say no. And I'm getting a text, what if they don't want the child? My answer doesn't change because they're going to claim to the court that they want the child. Oh, Judge, I want to be so involved with my child. They're taking them away. I'm not going to be able to see them. Whether they have seen them 0 times in 10 years or not, they're going to say that. It is manipulation. They are using the court system against you. Again, that's that control that they have. They're using the court to control you. And once you have a court order, you are obligated to do what the court order says. So, as helpful as it may be, if that other party is not in agreement, I would tell you not to do it. Doesn't mean that you can't move within the state.
We had another question about financial values. Someone is asking, how do you estimate the current financial values broadly?
I would go to some apartment complexes, figure out if I want a two-bedroom apartment, figure out what the price of a two-bedroom apartment is. I'd get a few estimates. I'd call Spectrum to see what a basic internet plan is, what a basic phone plan is. You just got to do a little bit of research to get those numbers. I would print those estimates off if I could and present to the court. This is the estimated value of renting. We know that it's expensive to rent. If it's reasonable, the court is going to believe you.
We have another question, I think, relating back to that, traveling out of the country. Am I allowed to send my kids to India while I stay here for work and career reasons before the custody order is in place?
If a complaint has been filed, I would tell you, no way, don't do it. If there is not a complaint filed, you are technically free to do whatever you want to do. An officer will not get involved, but again, you run that risk of emergency custody. And if your children are school aged and they are in school, there's no way a court's going to allow that to happen because you're interrupting their education.
We also have another question. I lived in North Carolina for a couple of years. Can I stay in a different state during the separation period and file for divorce in North Carolina later?
If your spouse lives in North Carolina, if your spouse meets that 6-month requirement, residency requirement, then yes, you can file in North Carolina. But I'm going to tell you, North Carolina has about the longest separation period of any state. So it may be more beneficial to file in the state that you move to. Some are as low as 30 days, 6 months. We're a year and a day.
While we just wait for more questions in the chat, we had some questions sent to us before for people who couldn't make it. So, one of the first ones is, in the process of living separately for a 1 year period, is it advisable to file taxes separately or do it jointly under until the divorce is done?
I think that's a decision you make with your spouse. Many times it's more financially advantageous for you to file married. You may get a little bit more money if y'all can agree to how to split any potential refund. But that's a personal decision.
We had another question. What are the things to avoid before filing for divorce with respect to finances, assets, any red flags you see?
So I somehow got on a listserv for another law firm, and they sent out this list of things, of ways to pay your attorney. And one of it was to pull money from your retirement. Never would I ever say that. That retirement is subject to being divided by the court. And if you have spent that money, you are still responsible for giving your spouse half of that retirement money that you spent. Um, so I would not spend anything that is considered marital or that has the potential to be considered marital. And marital is anything that was acquired from the date you were married until the date you separated. Even if you had a retirement account in 2010, got married in 2020 and separated in 2025, there's a marital portion from 2020 to 25 of that retirement. And no layperson can determine what that marital portion is. I would not touch that. I would not move money. A lot of people do this. They drain the bank accounts. The men drain the bank accounts and leave you with nothing. I wouldn't do it. If there's $20,000 in that bank account, you're entitled to 10,000. So if your spouse has removed that money, again, this is knowing where you bank. We can figure out how much was in that bank on the day that you separated. And he's still required to give you that $10,000, whether he has it or not. He'll be ordered to give you the $10,000 once it's ultimately divided.
And going along with that, retirement, we had a question, is there a way to protect my 401k from splitting? It was opened after the marriage, but the contributions are mine.
The contribution are y'all's and the court sides. It is your spouse's and your contribution because it happened during the marriage. But yes, there are ways. So many times there are houses, cars, bank accounts, retirements. When I say that the court is going to split it 50-50, the court is not going to say, okay, Kushi, you get the 10,000 retirement. Yasmin, you get the 10,000 retirement. You get the $5,000 in the bank, Kushi, and Yasmin, you get the 5,000. We throw all the numbers in the pot and then we divide and come up with an amount owed. So you could potentially keep all of your retirement, but you're going to get less of something else in order to balance that out. Because the standard is that we divided 50-50. Abuse may be a way that you can ask the court to give you more than 50%, but for the majority of the cases, it is divided 50-50. Many people want to keep their retirements, and many people finagle the numbers any way they can to keep their retirement.
We had a question about child support. My adult kid who is on the spectrum will be living with me. Is he eligible for any child support?
After a certain age, no. And off the top of my head, I believe that age is 20. At that point, you need to get some other services for that child, especially if they have already graduated high school. So no, they would not be eligible for child support if they have already graduated high school.
We still have a few more minutes, so we can keep going with the questions. Does the parents' eligibility depend on marital style, status, household income, or whether a formal separation has been filed?
Eligibility for what?
I
Child
think
support?
maybe, yeah.
Read that
Or
one more
maybe custody. This was a
time.
pre-sentence question, so
Read that to me one more time.
yeah. Does the parents' eligibility depend on marital status, household income, or whether a formal separation has been filed?
For divorce, no. Again, there's no such thing as a formal separation being filed, so we can scratch that part of the question. Um, you have to be separated typically in order to get child support and alimony. Um, your legal status, I don't know if that was even part of the question, but your legal status does not matter. You are still entitled to child support. You are still entitled to alimony, and you're still entitled to your property being divided.
If there are currently no legal proceedings or custody orders in place, is a parent legally allowed to move to another city or state with their child? This kind of
Again,
goes along to the other
right.
questions.
You can move, but you may be moving back to North Carolina with your child if they file for emergency. It's always best to have the consent of the other party. If you can obtain the consent, yes. If not, as much as it sucks, which is not a legal term, you're going to be stuck here unless a court gives you permission to move. But a court will give permission to move if you can give a compelling reason why. If you're going to transfer from a $12 hour job to a $12 an hour job across states, no. But if you're making $12 an hour here and you can make $50 an hour in Virginia, that may be a compelling reason that a court would permit you to move.
And we can do one last question from the pre-sentence questions. Is it okay if I visit India before filing? Will that be considered as a red flag because of the flight expenditure?
Visiting by yourself, no. Visiting with the children, not necessarily. But again, that goes back to the emergency custody. I just saw a question pop up.
Yeah, we had a question in the chat. My alcoholic husband refuses to leave the home to start separation. I have zero income, disability, and four minor children. How can I force him to leave?
So separation is voluntary in North Carolina. You can't force somebody to leave, but there's always an exception. and that exception is divorce from bed and board. It is not a divorce, but when both parties are in the same home, if there's about 6 reasons that a court would grant divorce from bed and board, and that alcoholism, we could fit that into a category. You would file a complaint for divorce from bed and board, allege the facts to the court, ask the court to A, create your date of separation, and B, courts will typically order the other spouse to move out of the house. However, it is always a risk that I go over with my clients because you will file that complaint for divorce from bed and board and still be living in the house with your spouse until you have that court date. People have done it, they do it, but if your safety is at risk, you really need to think about whether that is the best move for you. There's a common, and I know you said that you don't financially have the resources, but there's a common misconception that if you move out of the house, that is abandonment, and you are giving up everything. That is a lie. That is not true. You can't get a divorce without being separated. Somebody has to move out of the house. You're not losing anything by moving out of the house. You're losing your sanity by staying in the house, probably. So it's okay to move out if you have the means to do so.
Don't see any other questions in the chat, but I'm going to give it another. Do we have special financial arrangement for the special needs child who will not graduate the regular pathway?
Not through child support, because there's that age cap. Not through child support, you do not. So not through family court would be the answer. But if you're asking for alimony, I would throw that in as a consideration for alimony when you're asking for however much you need because you consider that special needs adult child that is living with you. Oftentimes we say adult children paying for adult children is voluntary, but this may be a circumstance where it's not voluntary. They need you to support them.
I had another question. If we have to leave, husband will not and has physically stopped me before, can I take my kids?
So I always tell everybody there's this legal attorney hat that I wear and this mom hat that I wear. And so I'm taking off my legal hat and telling you I'm not leaving the house without my child. I'm never leaving a house without my child. And if there's no custody order in place, you're taking your child with you. That's what I tell every single client.
All right. We don't have any more questions in the chat, or we don't have any questions that our clients have sent us before. Um, Thank you so much. That was a really comprehensive session. I think all the questions that our clients had sent us before had been answered. Thank you, Attorney Morton. Thank you, Kushi, so much. We really appreciate this time and the comprehensive information that you provided. If we receive any further questions, we will forward those questions to y'all. And yeah, thank you so much. And thank you everyone for joining with us today. I think this is really helpful, and most of the general questions most of our clients had were answered, and we really appreciate that and looking forward to have more collaborations in future.